Thank you for tuning into the Bully Pew Podcast, brought to you by Protestia.com. As always, go to Protestia.com for all of your latest in Christian polemics and discernment news. Sign up for the Insurgency News Blast. You can also go to insurgencynews.com for political news, cultural news, secular news, if you will, from a conservative Christian perspective. ReformationJournal.org for our deeper dives into the particulars of Christian theology. And yeah, it's an expanding network of websites, and hopefully influence, God willing, because we believe very firmly that this kind of ministry is as needed as ever, to be an independent voice of Christian conservatism that is not tied to any other institution or any other financial interest or something like that, giving us the freedom, if you will, to say what needs to be said when it needs to be said, and not be concerned so much about who gets mad at us or who decides that they're going to badmouth us to other people, or going to somehow scuttle our next job opportunities or something like that. So that's what we're going to be talking about in this Bully Pew podcast, the long-running and now complete, although not with even close to the resolution that we needed as churchmen, to the Will McRaney versus North American Mission Board case. This case was originally filed, and if I get some of these little details wrong, I apologize. I am in Studio C, which some of you know means car, an idea that I stole from another C another C program, the Christian Commute. I stole this idea from the Christian Commute's Seth Dunn. I make no apologies for that, but it does mean that I don't have a bunch of documents in front of me to make sure that I get 100% of these details correct. Although, quite honestly, like yesterday when I was recording when I recorded the Protestia Tonight episode on Ruslan KD's summit with Mike Winger and Wes Huff and some of these things, and then just the ridiculousness of that whole thing, I did see a picture of Alan Parr, and I called him Mike Todd. Make fun of me, please, about that, if you will. I saw in my mind 4-letter last name and said Todd in my mind, and it was Alan Parr, at the Christian YouTuber at last year's Ruslan conference, and not Mike Todd. Mike Todd, quite frankly, is too big now, too influential to be at something like this. But that's neither here nor there. This program, I have more of an excuse to get some of these details wrong. Back to the topic at hand. In 2015, Will McRaney filed suit. I believe it was in Mississippi, like a Mississippi state court, against the North American Mission Board for defamation, for torturous interference with his employment, with intentional inflicting of emotional distress, these kinds of things, for what had happened. Not to, I'll try to get through this pretty quickly for those of you that don't know. But basically, Will McRaney was the head of the Baptist Convention of Maryland and Delaware for a few years. They had an operating agreement with the North American Mission Board for church planting and other evangelistic activities. The North American Mission Board claimed that McRaney was violating that agreement, that he was making decisions on his own, that they were supposed to be in on the decisions. So, basically kind of a dispute of sorts. And then the North American Mission Board basically told the Baptist Convention of Maryland and Delaware that they were going to rescind the partnership, basically withholding, I think it was like $1 million of funding or something that was part of this agreement, on the basis of Will McRaney supposedly doing these things, not doing what he was supposed to do, or basically the North American Mission Board didn't like how McRaney was doing things, so they told the Baptist Convention of Maryland and Delaware, hey, we're pulling the agreement. We're backing out. And after this, the Baptist Convention of Maryland and Delaware, the BCMD, fired McRaney. They get rid of Will McRaney, and then immediately after this, the North American Mission Board resumes they pull their intent to cease the partnership. Basically, they had sent a letter to the BCMD saying we're going to cease partnership because of this XYZ, and that it was all McRaney related stuff as far as I know. Then the BCMD gets rid of McRaney, and then immediately the North American Mission Board pulls back. So, very clearly, I think by the evidence that the North American Mission Board threatened to pull funding from the BCMD if they didn't get rid of McRaney. They get rid of McRaney. Now, McRaney alleges in his complaint, again, this is now over 10-year-old complaint in the court. It was remanded to a federal court, to the fifth, I'm trying to remember which federal court it was. Doesn't particularly matter. Remanded to a federal court. And, but McRaney's claim, his complaints were that the North American Mission Board, both before and after his firing from the Baptist Convention of Maryland and Delaware, did things that were illegal under common law, under state common law. Things that were defamatory. They made false claims. They interfered, basically turned him into kind of a Baptist pariah. Through illicit means, things that were under common law in this country are not allowed to be done. These are tort claims, so they're not criminal claims, but they are claims of things like defamation, contract violations. These kinds of things are not adjudicated under criminal courts or criminal statutes, but they are adjudicated under common law statutes in civil courts. So, this is basically is moving through the early processes of a civil claim in federal court. Of course, this involves the cases going forward, then it's stopped, then it's forward, then it's stopped, so on and so forth, and eventually winds up in the Fifth Circuit Court of Appeals, Federal Appeals Court. And the federal appeals courts, of course, in the country are the highest federal courts before the Supreme Court. And in September of last year, the Fifth Circuit Court of Appeals grants a motion for what they call summary judgment. And this is where somebody basically makes a motion and says, look, none of the facts of the matter here, all of the standard facts of what's going on are not disputed between the two parties. Like there's no further like litigation, investigation, discovery, anything like that that's needed in order to determine who's telling the truth here. Both parties basically say, yes, we both agree this is what happened. Therefore, the ruling itself is just a matter of determining, okay, who's right according to the law? Who should prevail according to the law? The majority on the Court of Appeals ruled in favor of NAMB's motion for summary judgment, basically dismissing this case. And McRaney petitioned the Supreme Court to take up the case. They declined to take it up just a few days ago. If you read Protestia, that happened very recently, meaning that the Fifth Circuit Court of Appeals decision on this matter and on its particulars is now legal precedent, is now case law in the United States of America. Particularly in the federal court system. I mean, most specifically in the Fifth Circuit, the Fifth Federal Judicial Circuit, but also other federal courts would look to this as precedent. Even state courts, local courts may look to this as precedent of how to interpret the constitutionality of the matters that are involved. And I basically had argued, and you can go to Protestia and read about this. It's all in the op-ed section, so it's pretty easy to find. The concerns with this from a Baptist perspective, about exactly what happened, but to try to cut down to the real core of the issue, the courts in the United States of America have long held to a tradition that we might say would say ecclesiastical abstention or church autonomy kind of doctrine, which basically indicates that civil courts, secular courts, should stay out of religious matters of churches and other religious bodies. In other words, if it's going to take if the court is going to need to make a determination about a matter that is religious in nature, then they are, and honestly, it depends on which court you're looking to to figure this out. They either lack the jurisdiction to hear the matter, or the claim of like church autonomy, ecclesiastical abstention can act as a defense against charges against a religious institution. Those two things are a little bit different. In practicality, they play out similarly in terms of their effect, but there's a difference in, and I realize, guys, this is getting into the weeds, so I don't blame you if you say, hey, I'll try to figure out the summary of this at some other time, but if this interests you, the legal particulars concerning churches and religious institutions versus our legal system, we're going to keep going. The difference is a charge that's brought against a religious institution has often been basically dismissed outright, dismissed at the pleading stages, at the beginning of the legal process, on the basis that the court lacks jurisdiction to hear claims that are religious in nature. This is the rules of federal procedure, Rule 12 specifically, in the multiple sections of it, provide for times when a federal court would say, we actually don't have jurisdiction over this. We're not able to even hear this claim because we lack subject matter jurisdiction, or because we lack, we're the wrong venue, we're the wrong place for this to actually be figured out, those kinds of things. And so very often religious disputes are thrown out at the very beginning on claims like this. A good example would be if you had a Christian school and that Christian school has employment requirements, either specific doctrinal requirements, like, teachers at the school will hold to these specific doctrines, or even something more general, like the purpose of the school is to provide education from a God-honoring and biblical perspective, or something like this. And then that school decided, hey, teacher so-and-so is not adequately providing education from a biblical perspective. It's not biblical enough, or they're not holding to such and such a doctrine over here in deed or in practice or something. The church, or the school, I should say's determination of that is a inherently religious question. It's a question of religious judgment to say, okay, how much, at what level can we determine that this teacher is not upholding the doctrinal standards of our school? At what point can we determine that they're not providing an education that's biblical enough, or something like that? Like, civil courts will throw that out pretty much immediately, and quite honestly, they should. They should throw that immediately. This requires making religious judgments, religious balancing tests that civil courts are not equipped to manage. And yet, when we look, and the same thing, by the way, would apply if you're talking about it like a hierarchical denomination. If the Roman Catholic Church, if the Cardinal so-and-so or some diocese says, hey, that priest over there is disqualified for XYZ, the priest is going to have a real hard time turning around to a civilian court and suing and saying this was unlawful employment discrimination, or this and that. Like, the ordinary rules don't apply, because the standards of employment, or the standards of participation, whatever you want to call it, are profoundly religious in nature. They can't be adjudicated in the same way you can adjudicate something as simple as, say, this person agreed to this contract and then violated it. That's something that courts, can more easily adjudicate. This person agreed in contract that their house would act as collateral for this loan, and they're not paying the loan, and so by the terms of the contract, we can repossess the house. The person whose home is repossessed can't turn around and sue in court and say, hey, I actually did uphold the contract or something. The court is able to say, no, you didn't. And the issue that we're looking at with the ruling in McRaney versus NAMB here is under the auspices of, like, it took me a little time to read through and really parse and figure out the Fifth Circuit's, it was a 58-page, opinion, 58-page decision that provided a summary judgment in favor of NAMB. But what was immediately noticeable to me was that the the presupposition that religious abstention, the idea that a civil court would not interfere in religious matters, it was all presupposed around this idea that, hierarchical denominations and autonomous voluntary cooperation organizations like the Southern Baptist Convention should all be treated equally under the law, which is a good presupposition. The problem is that they interpreted this to mean that the result of a claim like McRaney's claim, therefore, should be the same result, and that result would be the civilian court, the secular court, stays hands off for all different denominations, no matter how they're structured. And I mean, this is a fundamental misunderstanding of how legal responsibility and authority work. The problem that we have now is, like, as Baptists, which you guys all know that I am, is we now have a situation where Baptists functionally have no place to go for justice in the case of a ministerial dispute between autonomous, unconnected, in terms of authority or whatnot, Baptist organizations. There's a loophole. There's a very clear loophole at this point, and the loophole is now being supported by a ruling in one of the highest courts in the land that says that equal treatment of religious organizations means treating hierarchical denominations that have agreed upon and practiced hierarchy the same as autonomous denominations, if you even want to call it that, autonomous religious groups that voluntarily cooperate with one another. This is a huge problem, because a big part of the reason that Baptist churches prize autonomy so much is because we don't believe that there are religious organizations that exist between, first and foremost, the believer and Christ himself, but then the church and Christ. The spiritual authority flows from the mediation of Jesus Christ through the hearts of spirit-filled believers who voluntarily associate with one another in local churches. And then those churches in Baptist polity voluntarily associate with one another in other organizations for common ministerial purpose. But this doesn't make them legally subject to one another. That becomes the problem. We basically have a situation now where, under U.S. law, the latest ruling in a high federal court is that Baptist organizations, by the thinnest of connection, I mean, the fact that they've cooperated on some sort of ministerial level, and by the way, that cooperation has occurred under supposedly legally binding documents, that because the subject matter of those documents cannot be, because the subject of those documents is religious in subject, that the ordinary components of the document, the ordinary decisions on whether the document was followed, whether there were lies told, palpable lies told about another party's involvement in following the document, that these are now off limits for ordinary legal remedies. In other words, like the whole purpose of Baptist autonomy is to protect the civil rights of its member churches, protect the civil rights of its organizations, protect their right to follow the dictates of their conscience before the Lord. Those rights have now been stripped away by our legal system, and we're now looking at voluntary Baptist cooperation as if the mere fact that two organizations cooperated makes them the same organization legally. And in other words, we functionally have a situation where if the proverbial hits the fan in Baptist cooperation, and a minister, a Baptist pastor or a church or whatever, basically goes toe to toe with one of the broader denominational organizations like the North American Mission Board, the Executive Committee, the NAMB, whoever it is, and that organization acts potentially illegally. they actually break the law in their dealings with the church or the pastor, that church or pastor has no remedy at this point. If they go to the civilian courts under ordinary tenets of common law for redress, that court is going to say, hey, you guys are all one church. That's not our problem. We can't actually adjudicate this. This is a huge problem. I mean, we have a situation where we're one step away potentially legally. And I really don't think I'm overstating this, although I know that people on the other side of the issue might say, hey, that'll never happen. There's no way. Like we have a situation now where at the federal court level, they are looking at any voluntary cooperation between Baptist entities, Southern Baptist entities. So your Southern Baptist church, if you're a Southern Baptist, Southern Baptist parachurch ministries, any of these organizations that are connected by any sort of a stated ministerial purpose, may now be legally bound to one another. We're one step away from some creative, clever lawyer deciding that your church is going to be a co-defendant the next time that the Southern Baptist Convention finds themselves the defendant in a lawsuit. They will be able to point to this Fifth Circuit decision and say, hey, very clearly, the decisions here were made as one organization. Your Baptist church is partnering with the Southern Baptist Convention. There are documents that govern this ministerial connection, this ministerial partnership. Therefore, they're connected with, they just sent a check to the cooperative program, they just sent a check to the North American Mission Board, or they just sent a check to the NAMB or whatever it is. And because of that, they are culpable in a ministerial sense, in an organizational sense. They're culpable for the deeds of the Southern Baptist Convention. Let me ask you this. Can your church, again, I don't want to overstate this, but I want to be real clear about the danger that this actually is. Can your Southern Baptist church afford to be party to a multi-million-dollar lawsuit because of your ministerial association with the Southern Baptist Convention? Because it would not be difficult. I'm not a lawyer, as you guys know, but it would be very easy for me to write up a legal theory using the Fifth Circuit Court of Appeals decision in the McRaney versus NAMB case and tie your church to anything I wanted to if I was a prosecuting attorney. If I'm an attorney for the plaintiffs, again, I'm not an attorney, I want to make that clear, but if I were, it would not be very hard for me to, again, using now federal court precedent, to tie your church, your Southern Baptist church, to any misdeed of any other Southern Baptist entity that I wanted to, and say you are legally responsible for this as well. You are a co-defendant. That is, I don't understand how that would be a tenable risk for any Baptist church to take at this point. We all saw how the wheels came off of the sex abuse task force, and the fact that they couldn't help themselves from making claims in the investigation that they couldn't demonstrate, and it put the whole convention at risk. The executive committee is still paying for lawyers and potential settlements and all of this because of the actions of a small bit of the SBC and the actions of a third-party investigative firm that the SBC for some reason decided to take responsibility for, financially speaking. We're talking about a choice by the executive committee to indemnify Guidepost Solutions. So whatever Guidepost did, the SBC agreed they'd take responsibility for it, and now that includes defamation claims, right? So the David Sills, the Johnny Hunt kind of issues cost the Southern Baptist Convention millions of dollars, and probably still will, because of a handful of bad decisions made by SBC leadership. Now we have a further court precedent that basically establishes the idea that ministerial cooperation, any sort of agreement between SBC entities, your church, again, your church, your state convention, and things like this, any sort of agreement that has any sort of ministerial terminology whatsoever, any sort of religious terminology, anything that would honestly rightly be we would say non-cognizable, maybe. I mean, something that the federal courts or the secular courts would say, we can't make a judgment about this. Anything that you've agreed to in any way with any other SBC organization is now categorically going to make the civil courts off limits to you. You're not going to be able to go to a secular court for remedies in the case that you are a co-defendant. I mean, you're just going to have to pay up. You're just going to have to hire lawyers and pay up. This is a terrible situation for Baptist churches. Now, it should be understood. This is really important because there's a lot of people who are talking about this. I mean, and granted, this is sort of a niche issue. But it seems like a niche issue. I mean, I'm trying to explain why this is a much bigger and broader and more dangerous thing than people are giving it credit for. But in terms of its social media activity, it seems pretty niche in sort of Southern Baptist legal circles, so to speak. But there are folks claiming out there basically that the Fifth Circuit Court of Appeals ruled in NAMB's favor, and they're just sort of leaving that out there like that's the be all end all of what happened. And I want to explain that while yes, they ruled in favor of NAMB's motion for summary judgment, and then basically made the judgment that, hey, we can't touch this because we're not supposed to be involved in religious matters. That's basically the real quick summary of what happened. But they didn't actually rule on the merits of what Will McRaney had charged in his complaint. They didn't, and they basically said, hey, look, we can't, because his claim, in order for us to adjudicate his claims, in order for us to figure out whether he actually was harmed by NAMB in this way, we can't get past having to rule on things that are religious in nature, things that we are constitutionally barred from ruling on, basically. We would have to start to get in the weeds of whether or not Will McRaney was upholding certain religious components of the agreement between the BC MD and the North American Mission Board. We can't rule on that. Therefore, we have to rule in favor of NAMB's request for, their motion for summary judgment and dismissal of this. And yet the question, and so the question has never been actually argued before the court or decided in any way of whether the things that McRaney said NAMB did were even done. And the problem is that you have a document here, this operational agreement or this cooperation document or whatever it was between NAMB and the BC MD that has certain religious components in it that I would totally agree with NAMB and say those are off limits for civilian courts. The civilian court should not be deciding whether or not broader goals like the forwarding of the gospel and the proclamation of the name of Jesus Christ, or what sort of these broader religious components of the document were being exercised or were being properly promoted and executed by Will McRaney. They shouldn't be deciding those kind of things. But there are components of this, like an example would be, Will McRaney, one of his charges was that the North American Mission Board said he was violating the agreement by unilaterally making decisions that they were supposed to be involved in. And Will McRaney's like, no, I wasn't. Here's the email evidence that I wasn't doing what they were saying I was doing. And so, we already have this palpable evidence where one party makes a very black or white, yes or no kind of claim. The other party says, no, here's the evidence that claim is false. And we have a court saying we can't even decide that because both of the parties in this case are religiously affiliated with one another. Both of them say they're Baptist. Both of them had a ministerial agreement at one point. So in other words, the North American Mission Board can say he violated he did this, he did XYZ, and no matter how much evidence that McRaney can bring to bear to say, no, I didn't, here's the evidence that I didn't, they're lying about me. A lie is being told, a damaging lie is being told. The courts are saying, we can't touch that. Sorry, it's religious in nature. We can't touch it. And so again, the whole reason that, the major reasons that Baptist institutions want to be autonomous, which really is to retain their ordinary civil liberties, their religious liberties, their speech liberties, their associational liberties, their civil rights. In other words, their rights not to be have authority exercised over them by larger denominational entities. All of these things have now been, basically in a legal sense, shot in the foot at the very least. So, you have to recognize that in terms of the purpose of church autonomy, to not have authority exercised over a local church by a third party, in order to maintain that autonomy, there has to be an enforcement mechanism for that autonomy. And that enforcement mechanism cannot be either one of the entities themselves. This is standard, common Western civilization common law. Authority doesn't generate itself. So if a church says that we want to assert our religious liberty to conduct our church the way that we want, to have our own bylaws, our own constitution, pick our own leaders the way that we want to do it, free from any sort of authority over us, this presupposes that church is going to need potentially, hopefully not, but potentially, if something goes wrong, an enforcement mechanism, a place to go if their rights are being infringed upon. And ordinary civil rights, we're talking about things like the right to have our own church property, the right to not have our reputation besmirched by other entities. There were people at my Southern Baptist church when the sex abuse thing was sort of blowing up a few years ago, that basically admitting, to our pastors, we're not comfortable being members of this church because you're part of the Southern Baptist Convention and we hear that you're full of sex abusers. That wasn't true, obviously, but nothing at this point would prevent the North American Mission Board or NAMB or NAMB, the IMB, the Executive Committee, any of these Baptist entities, nothing would prevent them at this point, legally speaking, from saying, hey, we don't recommend, we're going to disfellowship you from the SBC. Basically the voluntary cooperation, we're going to remove our consent from that. So we're not cooperating anymore. And by the way, we're going to publish a document on our website saying how terrible your Baptist church is. Nothing would prevent that at this point. And that really this is happening, but more to individuals. I don't know what the court process would have demonstrated, proven one way or the other in the McRaney case. It was never allowed to be adjudicated. The standard common law components of this now are off limits to Baptists, now off limits to churches or institutions that cooperate with the Southern Baptist Convention. And quite honestly, this would apply to any religious tradition that organizes itself through voluntary cooperation. You've all now basically given up your common law rights to not be defamed, to not be materially harmed by false statements and false words by other institutions, just by partnering with them voluntarily. It sounds like even if that voluntary cooperation ceases at some point, you still don't have your rights. They're still going to, the organization that you sue is still going to claim abstention. They say, hey, the courts can't touch this. It's a religious matter. Whether or not somebody violated a contract and we lied about it is now all of a sudden a religious matter. This is a huge problem for Baptist churches. Again, the reason that we insist on autonomy is because we do not agree with the fact that there are superior religious organizations that we fall underneath that have authority over us. But again, in order to enforce that, in order to assert those rights, to not have an organization over us that can do whatever it wants, and the courts can't touch it because it's a religious issue. In order for that, we have to have access to remedies in the case that we're harmed. This applies to our churches. This applies to us as individual Christians. I'm trying to remember the gentleman's name, but another similar case to this, where basically a guy was offered employment and then denied employment, removed from his church, all these kinds of things as a worship pastor, on the basis of charges that were never even brought, naked accusations that were never brought as charges, never demonstrated. Just somebody claimed something, claimed that he was, guilty of abuse or something like this, or had committed abuse. It was never adjudicated in the court, and he's hired and fired very obviously, very clearly by the evidence on the basis of these things, on the basis of these claims. Now, if this was any other situation other than within a church context, he would have remedies for this. He would be able to say, "You harmed me through your lies. You are not permitted to accuse me of things that are defamatory per se. You're not allowed to claim that I did things, insinuate that I'm guilty of crimes that have never even been charged, that have now palpably harmed me. You're responsible for the effects of your false statements and your words." This is standard Western civilization common law that we're seeing. But now with the Fifth Circuit's ruling on the McRaney case, everybody who defames anybody in a religious context is now they have a get out of responsibility free card. This has done such grave damage to Baptist polity, to the idea of autonomous voluntary cooperation in ministry. And a lot of the, supposed Baptist leaders that are out there are too stupid. I'm going to say it this way. They're too stupid to see what's actually happened. Your sort of platform pastor, Bart Barber types are out there claiming, hey, this is actually a win for religious liberty. This is fine. It's not. It's very much the opposite of that. He doesn't even realize at this point that, he served as the former president of the Southern Baptist Convention. Under this ruling, under this sort of broad application of church autonomy and ecclesiastical abstention that was brought to bear in dismissing the Will McRaney case by the Fifth Circuit Court of Appeals, any Southern Baptist entity that's had any sort of official connection with Bart Barber at this point could call him every name under the book and accuse him of all sorts of heinous, terrible things, and he would have no call for any sort of remedy for this, no matter how much it damaged him, apparently. So let's say that Bart is seeking a new job or a new pastorate or something like this, and some other Southern Baptist church or entity decides to make accusations against him publicly. Hey, Bart did this, Bart did that. Bart has herpes, whatever it is, right? These things that qualify as defamation per se. Bart Barber would have no legal recourse with which to stop that false speech, no matter how many job opportunities he lost because of it. And somehow these guys think that this is okay. They think this is a win for religious liberty. But they don't seem to understand that religious liberty is born by individuals and then given under terms by those individuals within certain contexts. The individual bears civil rights in this country, and that's the way that it should be. That's what's biblically just. God saves individuals. The Holy Spirit resides in the hearts of individuals, not in the hearts of collective groups of people. And those people bind together by voluntary association with one another, and they draw up terms, covenants, and bylaws and agreements with one another under which they will engage with one another ministerially. This is how this works. And in doing so, they give up a little bit of their civil rights in order to do that. And again, contextual. But in the case of McRaney versus NAMB, no such context existed. Like whether or not NAMB defamed Will McRaney is something that needed to be determined by the courts, and it wasn't determined by the courts. They basically said, "Hey, we're going to wipe our hands free of this." The opinion says just ridiculous things like that NAMB chose McRaney. That they chose McRaney. Well, no, they really didn't. I highly doubt that their agreement, the agreement between NAMB and the Baptist Convention of Maryland and Delaware, referenced McRaney at all. Like, not specifically, not individually, but the decision was based around the presupposition that there was an official, authoritative religious construct at play here, merely because the documents had some, more ministerial, religiously based generalities. But basically it said because it has some ministerial generalities, some things that are religious in nature, and we can't weigh in on those, we can't weigh in on any of it. Not even plain things like, did he violate this part of the contract? The non-religious components of it. And what we have now are basically Baptist organizations that have been removed, remove themselves to a degree because NAMB, in pressing this case this way, they brought this on the SBC and other Baptist organizations for sure. But even churches that would not have agreed with this have now been basically relegated to a place of otherness and non-participation in ordinary civil life and discourse. Precisely the opposite of what Baptist churches want to be, need to be, which is in the world, yet not of the world. That we affirm and we support every ordinary good that we see even in secular society. We don't remove ourselves from the society around us in terms of how we do things. We don't do things behind closed doors. We don't have religious secrets. The things that we believe and the ways that we practice and the ways we do things are all open for examination. That's how we're supposed to act, how we're supposed to do things. And yet now we have a situation where the Southern Baptist Convention is in its dealings with itself, in its organizations, its voluntary partnerships, is now saying, we're doing this by our own terms. Subjective terms that cannot be examined or ordinarily decided as right or wrong by the world around us. This is anti-witness. This goes directly against the witness to the world that should be to affirm what is good and right, and yet be able to stand against what's wrong. We're basically saying, we're sort of outside. We're in our own little place over here. Secular courts, somehow the common laws of our nations are somehow inadequate to determine basic right and wrong. It's a terrible position for evangelical churches generally to be in. To basically say, have we not been relegated out of the common stream of American society enough? We want to do it more. We want to get even further away from plain and ordinary participation in civic life. We think that individual Christians, they should participate in civil life and being a citizen and all this, but the institutions we voluntarily put together among ourselves can't do it. They're somehow now, relegated into some sort of special religious bucket that's outside of the stream of the society that we're in, and we think this is good for our witness. This is a terrible development. And for my part, I'll keep explaining as much as I can, and maybe with some specifics in social media posts and things, exactly what's wrong with this. But my prediction, I don't want this to happen, obviously, but my prediction is you're going to see more principled Baptist churches exercising their autonomy and saying, we're getting away from this. We cannot have our churches subjected to this kind of risk where, we can't be entering into voluntary ministerial cooperation with other Baptist groups if it means sacrificing our ordinary civil liberties, as both as individual Baptists, but also as Baptist churches and the state conventions and other partnership agreements that we might decide to enter into. It's too risky at this point. I think it's going to be, quite honestly, it's going to be devastating for Baptist cooperation. We'll see. Anyway, thank you for listening to this Bully P podcast. As always, stay tuned to protesty.com for your latest in Christian polemics and sermon news. I will talk to you guys again real soon. As always, Semper Reformanda.